Okay, we're going to call the meeting to order. If we could all stand for the flag salute. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. To take note that all commissioners are here and present today. Are there going to be any agenda changes?
No, there are no changes.
Okay. So we'll go to public comment period for anybody that would like to say anything that is not on the agenda today. Okay. We're going to go into public hearing 2016-085. And Miguel,
Wait, do you want to do the consent agenda first?
Did I not do that?
We just sort of jumped over.
I approved it in my own head. Okay, so we would like to go over the minutes of the February 23rd, 2017 meeting. Thank you, Peter. There is a correction right off the bat on page 1 for a motion by Commissioner Laddish, just a spelling check error there. You don't have the minutes?
Oh, I corrected them already.
You already corrected that? Okay, all right. Are there any other changes?
Not from me.
No.
Did you not at least get that? Do you need a second to read it?
No, I got
Okay. Can we get a motion to accept the minutes for February 23rd?
it. Second.
Thank you. All in favor?
Aye.
Motion carries. Now we will go to the public hearing of 2016-085, and Miguel, I'll let you take it from here.
Good morning to the Planning Commission. This is Miguel with the Planning Department. Today I'm here to present Appeal 2016-085. The subject property is located at 6319 Pinecone Way in Mount Ranch. The subject property is 6.399 acres. The reason for denial was lack of a seller's permit and a business license. Neither of these were submitted by the September 7th deadline as per 17.95.165.n.5 A and B of the urgency ordinance. During staff review of the application, staff noticed that the application was missing these documents on December 28th. Staff contacted Mr. Garcia, who is the appellant, on December 28th and to inquire about him as to why he had not submitted them. Mr. Garcia claimed that he was unaware that these documents were required, and he further stated that if county staff had let him know ahead of time that he would have submitted them in time, but he had no idea that they were required. On February 8th, this appeal was continued by this commission to today's date. At that time, Mr. Garcia submitted a declaration. In his declaration, Mr. Garcia claims that the reason that he did not submit these documents was because planning staff and the Sheriff's Department advised him not to get these documents until he was approved by planning staff. That way he wouldn't have to pay the associated fees. However, to acquire a seller's permit, there is no fee. There might be a deposit. This is according to the Board of Equalizations. And in terms of the county business license application, there's no fee associated with it until you pay. So that argument doesn't really make sense to me, at least. Furthermore, I asked the staff, planning staff who took in this registration if she had informed Mr. Garcia to not submit these documents. She claims that she's never informed anybody to not submit the required documents by the deadline. I also contacted the Sheriff's Department. The Sheriff's Department contacted or talked to all their staff that are working with cannabis, and same thing. They state that any questions regarding the September 7th requirements, they would direct the registrants to contact Planning Department, and that they would never tell applicants to not submit a required document. And that's it for my presentation, if there's any questions.
Okay. Does anybody have any questions of Miguel?
No.
Okay. Do we have representatives here? Good morning.
I'm here with Mr. Garcia today.
Could you please state your name for the record?
Ken Foley, F-O-L-E-Y.
Thank you.
And I have a modified declaration which deletes the reference to my being in trial. I have originals here that I would like all of the Planning Commission members to have in it to go into his file again, which documents his statement under oath as to what he was told when he brought in his application. And we're here today because we believe he was in fact told that. In fact, it makes a lot of sense if people knew what they were doing back in December of whenever that was. How many years ago was that? What year was that application submitted?
It was 1.5, it was almost a year ago, May.
Now, I don't think that was probably the original intention when that emergency ordinance was passed, that it was going to take 1.5 years to get some people the results on their applications. And it would seem to me that these things that my client is alleged not to have done are not things that affect the substance of his application. There's a character part in there that I know has been a problem for a lot of people. And this is not the first time I've heard somebody tell me that they were told, well, why don't you wait and see? In any event, Mr. Garcia is here. If you'd like me, I'll have him swear under oath that what's in this declaration is true. And that's what we've got to say about it. We think that this application should be remanded back to staff and give Mr. Garcia a period of time to take care of those formalities that haven't been done, and then they can process his application like everyone else. I mean, you just can't say that there's not room for misunderstanding in this process.
I have a question.
Sure.
What does the sheriff's office have to do with the seller's permit requirements of the urgency
I have no
ordinance?
idea.
You haven't read the ordinance?
No, I have nothing. This is Mr. Garcia, who went over to the sheriff's department and spoke to them. I did not. I've never spoken to the sheriff about this.
I'm not talking about speaking to the sheriff. I'm talking about in the contents of the urgency ordinance, the sheriff's department has a very defined role.
They do.
It doesn't appear to me to have anything to do with the seller's permit requirement.
Oh, probably not. I've read the ordinance numerous times.
Then why would the sheriff's department volunteer something about the seller's permit requirement?
I have no idea. You could ask Mr. Garcia that. He's here. Or you
Okay.
could ask the sheriff. I mean, whatever is said there is what Mr. Garcia did and happened to him. So, you know, he can come up here and explain to you. He explained to me that there were 3 people in the planning department office at the time he submitted his application. And in addition to the woman who was, I guess, behind the counter. And if you'd like to hear him tell you what actually happened that day, he does have a recollection of that.
Okay, I have another question for you. Now, assuming that both the sheriff's department and the planning department, told him that he needn't file these documents because of he could save the money. Just assuming that, how do you establish the additional conclusions that are necessary to find that the county is stopped from the action it's taken?
Well, the question is, does the county have a straightforward procedure that they used in every case? I mean, I don't run the planning department.
I'm referring, there are definite additional layers of holding a county is stopped from its enforcement proceedings. And if there's a strong public policy that is in place, the county cannot be stopped.
Well, you know, I don't think this emergency ordinance has any strong public policy attachment to it. I mean, I think it was pretty poorly done in the beginning and has been wreaking havoc for the last 1.5 years in this county and to our citizens.
If you read the findings, you don't find that there's very serious public policies involved in controlling the cannabis cultivation?
This is the way that it goes. First of all, I don't believe this emergency ordinance has that attached to it. I don't think there's a strong public policy in how they handle this ordinance as compared to making sure somebody submits a bid on a project that they're doing for a public agency. Those rules have different reasons. The reasons behind the strong public policy is so that the taxpayers don't get the shaft. That's the bottom line on those strong public policies, and sometimes innocent people get caught up into that. This emergency ordinance, they didn't even process these applications in a timely manner. I mean, this is a bizarre situation where they still haven't processed, I understand, hundreds. And it's all going on the second year. So don't tell me the process had some type of special importance to it. 'Cause
I'm talking about the ordinance itself that
Right.
sets forth the great environmental concerns, which are public policy concerns, behind the ordinance to make sure that things were limited to what cultivation was going on then in the county and to protect the public from further problems. There's strong public policy behind this.
Well,
ordinance.
I don't see it in that ordinance or in the way it's been handled by the county. Let's face it, became much bigger than anybody thought it was going to be, and staff didn't have the manpower to deal with it in the beginning, and that just created one problem after another. I'm here on a very simple situation. You know what it is. My client's saying that he was told, hey, why don't you wait and see if you get approval. That seems reasonable to me. I could see somebody saying that and giving good advice and doing it, except now we've had a change. And we had a change probably about a year or so ago on this situation in the county where the cultivation of marijuana is not perceived as it was maybe a year and a half ago. I think it's a completely different world we're living in today versus a year and a half ago. And so I think maybe now we have these hard and fast rules that we're applying, which were not applied back when everything was, happiness.
Mr. Foley, I just want to, for one thing, I want to bring clarity. The ordinance wasn't put in effect until 10 months ago. Second thing is that there is policy surrounding the failure of your client to get his seller's permit and business license. The ordinance is very clear. If you read 17.95.165 in 5, clear as a bell. You have to get a seller's permit, you have to get a business license. And when you want to speak to the regulation of the urgency ordinance that we're currently enforcing, I take issue because these people were operating illegally to begin with, many of them. They didn't get permits for their hoop houses. They didn't do a lot of things that needed to be done. Yes, they could operate under the caretaker rules that were implemented and applied by the state, but many of these people did not have the proper water uses, the proper drainage. They were grading their land without permits. This was a health and safety code that we didn't have a lot of time to put into place. When it did go into place, it was for health and safety reasons. I personally hold all of the applicants accountable to comply to these rules. There were reasons. His environmental issues were one of them. Maybe it's not written to perfection, but we had to stop the chaos that was going on, and I'm sure you'll agree that once the governor signed his legislation, chaos started. I have a really, really hard time believing that anybody in the planning department would make a statement, hey, don't follow the ordinance, don't get the permit. Their job is to enforce the ordinance, and that was a very clear ruling on being on September 7th, getting a seller's permit. I have a hard time that the Sheriff's Department would even entertain talking about that. They're there to do a background check application. They're not there to instruct them on how to follow through with the ordinance and moving through. That would have been in the planning department's hands. So I am struggling with that. I would love to hear from the appellant and let him tell us why he would have had that conversation with the Sheriff's Department. I think that's important to hear. But I don't...
He's here.
That's great. I'm glad. I don't think that somebody verbally telling him, you don't have to follow the ordinance, is acceptable. I think that as an applicant registering to be a commercial cultivation grower, it is their responsibility to get the ordinance, follow the rules, get their permits in place if they can, and get their application completed so they can finally get their permit. Yes, it has taken a long time to move through all of these applications. We're 10 months into this, and we still have a lot to go. I'm sure that we're going to see more things come up between now and who knows when, but it was an urgency ordinance under health and safety, and it was a crisis in this county that had to be addressed. We're doing our best to address it. We did have to gear up on our staffing levels. I mean, when I look at this whole thing, I know a lot of people have said the land grab was the reason we had to stop it because of the Butte fire. I don't believe the Butte fire was the contributing factor. I believe that the governor signed the legislation, gave himself 2 years to get ready to gear up for this, and gave all the counties, 58 counties in this state, to either ban or regulate. We didn't have 2 years. We had to jump through hoops to deal with this, and that's where we're at today. We're dealing with it. Patience is a virtue that I don't have a lot of, but during this process, we all have to gain some of it. So I think at this point, I'd love to hear from your client as to
Sure.
why he had those conversations.
And by the way, could I get somebody to pass these original declarations out to the,
Can you
Planning
hand those
Commission.
to Annette, and she'll make sure we all get a copy? Thank you for bringing that.
Hello,
Good morning.
good morning.
I'm sorry, Mr. Follier, is the content the same as what was distributed?
Except I took out the paragraph that I was talking about.
Okay, thank you.
It's exactly the same.
Okay.
so you really don't need to read it if you take my word for it, but then again,
Okay.
I'm Carlos Garcia. What I put my application in was one of the first ones that I see, I think it's number 85, the applications. And when I put it in, and I was at the office right over here, I've had all my documentation, my check, pictures, and everything done. The reason I have my property in an LLC from another state, and this is what started the whole thing of transferring everything over, why I did not get my seller's permit, because I didn't have an LLC here. So the lady behind the counter, she was about my corporate documents for my property. And she said, well, do I need to transfer it over so I can get my seller's permit in an LLC here and get my property put into an LLC here and open a corporation here? And she's like, we will be in touch because you're just putting your application in. We need to see if you pass, why do the expenses. Other than that, if I had a business license and my seller's permit, PG&E would give me a 35% discount on my power bill. And I didn't have that because I didn't know if I was approved or not. Because I had to have my approval to be able to go to PG&E to even get my 35% discount on my power bill. And I hadn't heard anything from anybody, and since I put my application in, off the top of my head, it was June 10th, I think, or June 8th. And then I'd never heard anything else. Then the next month, I did my background check. I was at the sheriff's department. It was a blonde lady, took my fingerprints and everything there. And when she did it, I go, well, do I pass? Because I have some other things to do. She goes, the county will be in touch with you to fulfill if you know you passed your background check.
Now,
Because if you don't pass your yes,
Excuse me, Mr. Fuller, Mr. Garcia. Did you, at that point, in your declaration, you say that the sheriff's office also told you that you didn't need to get a seller's permit?
That was when I had my fingerprints done and everything like that. I go, it was in July, which was a month. I said, when do I know if I'm approved so I can finish? And she said the county will be in touch with you to know about your approval,
But
basically.
in your declaration, at least
I
it's the
must-
same,
I must- Well, that was the lady at the sheriff's department.
you say that the sheriff's department said that I should wait to obtain the other required documents, i.e. seller's permit and business
Once I
license.
know if I was approved, if I passed my background check. Because you had.
No, then in your declaration, you say, until I had approval from the planning department. I just don't understand
Yes.
why a seller's permit and business license
Because
would
of my-
even be brought, would
Because-
even be brought up at the sheriff's department.
Because I needed to know if I had to get all those paperwork to put in because I had to transfer my property out of the LLC Corp that I had it in and put it here so I can have my business license done, the LLC done here, and all my new permitting and transfer all the corporation names here. That's the reason that they said to wait to see if I had approval.
That the sheriff's department told you that as well as the planning department?
The lady that I asked, my fingerprint said, your approval, you'll know in a couple weeks if you're approved, so you know if you can move forward with doing anything, basically.
Okay, that isn't quite what you're saying in your declaration. Do you want to take a look at that? Number 4?
Just, the Sheriff's Department. Yes. That's basically what I meant was I was advised that with my approval, then I would know when to move forward with my application if I was approved or not.
So the sheriff's department didn't specifically say seller's permit and business license?
No, sir. Not that I recall.
Paragraph number 7 also addresses that in the declaration.
Order 6. No, planning base. Okay.
Do you have the new,
No, I have the old
or
one.
the numbers are going to be different,
Okay.
I think.
4th to last paragraph of the old one.
Another question I have for you is, on December 28th, 2016, did you have a conversation with the planning department?
Yes, Mr. Michael.
And did you tell them at that point that you were unaware of any seller's permit requirements in the urgency
I had
ordinance?
not heard anything
Excuse
about yes, sir. As much what I recall, he called me, I was out of town, and I spoke to him I returned his phone call, he had left a message for me, and I called him back, and he said I was denied, and I had not even known that I was approved, because my whole basis was I had to transfer they wanted me to transfer my corporation from my LLC, which is Tropical Land Holdings LLC, that the property's in, to a California corporation, and when I knew I was approved, I was gonna do all the paperwork for everything, to buy everything in the California corporation. That's why I said I couldn't do it twice.
So, but I understand from the planning department that you told them that you were unaware of any seller's permit requirement,
Yes,
okay?
till my approval came through.
Are there questions from any of the other commissioners?
Yes. There's a form entitled Medical Cannabis Cultivation Registration Instructions for Filing Form. One of these things. Did you see a copy of that?
Yes, sir. I've seen it before.
Paragraph 8 says, for commercial site registration, the following must be submitted. It says, attached copy of California seller's permit must be received by planning department no later than September 7, 2016. That's underlined. It says, attached copy of current Calaveras County business license must be received by planning department no later than September 7, 2016. That's underlined too. And you were aware of those requirements?
I've seen them, yes, sir.
I got a question for Mr. Foley. Is it your view that a county staff person has the power to waive or modify the requirements of the urgency ordinance and bind the county by doing so?
You know, normally the answer to that question is no. That's the normal answer. In this situation where it is...
Mr. Foley, can you step on the mic,
Sure.
please? Thank you.
In this situation where it is the staff who are actually handling the application process, then it becomes a little bit more cloudier in my mind, because if you can't believe the people who are administering the applications, then who can you believe? And so that's why in Mr. Garcia's situation, I thought this was very simple. Either this happened or it didn't happen. And I have no reason to think that he's going to want to spend thousands of dollars on something he's making up here today. I do believe that somebody told him why don't you wait? And you know, the beginning of this, which he highlighted, I'm actually learning also here, because apparently our county wouldn't let a Florida LLC own the real property, which was going to be subject to the ordinance. I mean, it sounds like there was a question as to whether or not he probably could not get a seller's permit in California based on a Florida LLC. And so that could have created an issue, which I certainly wouldn't expect staff to immediately know the answer to, but that's what I think started this whole process of changing how he was, fulfilling his part of it, because there was still another question as to whether he was going to have to switch title, I guess, into some California company in order to get the resale permit. It's like getting a bank account. You have to have the right type of resolution from your California corporation to go in and get, I guess, a California account. Anyhow, so that's our position on this. It's not complicated, and you do have Mr. Garcia's statement under oath here. You don't have anything under oath against it. So if in fact there's this person who handled his application in the beginning has a recollection that they didn't say something like that, now's the time to say it.
But you do have the burden of proof, correct?
Yes, and we have a declaration under penalty of perjury here that we've offered to this commission. So that's where we stand on this. How you want to approach it. We know what the result is going to be. I mean, you just have to look at what's been going on in the county. So we understand that side of it.
I don't understand what you're just saying.
I'm just saying that the number of applicants who are getting approval from the Planning Commission over the last 6 months or 7 months has been a probably record low percentage. And the excuses that the staff and the county are using to defeat applicants is sometimes even mind-boggling. But that's the world we're in right now. We have an initiative or a matter on the ballot to ban this type of situation, and so we know where we're at. The problem is, if you believe it happened, then you should do the right thing. That's really what we're saying. If somebody at staff did make a statement that maybe they shouldn't have made, if they made that statement because of the unique situation that he had being a Florida LLC, then you should do the right thing. There's nothing that says government can't do the right thing. So that's what we're here asking you to do, is you could reopen the door, remand it back to the commission or to the planning staff and say, okay, Mr. Garcia has a week to take care of these issues, or something like that. And then he could be in compliance, and there's no prejudice. I don't see any prejudice to anybody except...
Well, you're talking about how long this whole process is taking, and if there are remands of every case, it would take even longer then, wouldn't it?
Well, if it's the right thing.
We will do the right thing.
If it's the right thing to do, if it takes a little time, so be it. But hopefully the citizens will get the benefit of the right thing rather than possibly doing the wrong thing for expediency or some other reason. So we want to thank you for your time here today, and we hope you understand that this is really simple. And we think we've met our burden of proof here with our declaration under penalty of perjury. And if that's the case, I know of nothing stopping you from doing a remand. Thank you.
Thank you.
Thank you very much.
Thank you. Okay. Is there any public comment on this agenda item? Okay. Mr. Turner, do you want to let the public guest go first? Thank you very much.
I just kind of dealt with the same
I'm going to wait till you get up to the mic, so we're going to have you give us your name, please.
I'm Max Sanfilippo. I kind of dealt with some of the same issues as him with the county, just a lot of unclarity with all the, the documentation and everything. I knew that there was the seller's permit and all that was going to be part of it, but I wasn't quite sure on the timeline. I know it's stated in there, but I was waiting for background checks and, just, it seemed very unclear from the get-go, dealing with the county, with all the permitting. You go in there, they say, we want this, this, and this. You bring them this, this, and this, and they're like, no, we've changed it, now we want this, this, and this. It just seemed it was very unclear from the get-go. I don't know, it was a lot to deal with, and I'd been here for a while, and I'd always just gone on the state regulations where I pay the state for, more of a plant number for personal use. And then when all this came in with the cultivation, you're saying whatever it was, 100 square feet per card holder. And, it's just not sufficient if you use it. And it's like the money that you'd spend at dispensaries, and when we're purchasing this land, where all the money is being spent in Calaveras County. So, I just feel like it's a good thing for the county. I never even grew the pot before. I worked construction, and I saw big increases in that for me doing that, helping people with piping and irrigate, just the whole thing, really. And then it allows me to stay here because I usually commute to the Bay Area, a few times a week to work, and it kills you because there's no work up here, Am I going to work at a gas station and barely get by, especially with kids and health issues and things like that. It just seemed unclear, and, I'm here for the same thing as him, just hoping that, you'd let us try and make all the requirements, because we've spent money on this stuff in the county. All the jobs go to you guys, to workers, to everybody gets a portion of the pie in our county for this, I feel like. And it does a lot less. I live up on Summit level. The impact from the growing is nowhere near the impact from logging. I mean, the destruction that the loggers have created up where I live is ridiculous. The bark beetle, I mean, we need the money and the income more than anything now, it seems like, especially where I'm at.
Okay.
So.
I was just going to say, we need to try and stay on the agenda topic, which is the applicant.
Yeah,
Okay.
I mean, it's just very unclear, and same thing as him, I was waiting for background checks. I realized that I need this stuff, so, I mean, it just, I'm in with him, like, it was unclear. It states it in there, but it was like, oh, well, maybe, and then what goes on with the ban now, we're doing all this stuff, and then they're just going to ban it, and we've invested all this money and time, and then we're going through this right now, but then who knows, in 2 months, it just all gets shut down, and it was just, I'm like, what am I going to do, So.
Okay. Well, thank you for your comments. We appreciate it.
Ethan Turner, Deputy County Counsel. I just wanted to clarify that there is no restriction in the urgency ordinance that prevents the land being owned by a out-of-state entity. So I don't know where that confusion could have come from, or why there would have been any hesitancy on the basis on staff's part regarding that issue. And further, if he was to later form a California corporation in attempt to transfer his registration into that entity's name, that would have been unpermissible in the ordinance. I mean, so
Permissible or
impermissible. You can't assign registrations from one entity to another or one individual to another. So it's unclear to me what any of that confusion could have possibly been about.
Thank you. Is there any further public comment? Okay. Do you have any rebuttals, Miguel, that you'd like to address?
No.
Okay.
Madam Chair, I'd like to maybe put things into perspective a little bit. This was filed on June 6th. It was fairly early on in the registration process. 085 was the number. It was probably one of the top, the first 30 or 40 that we received. I can imagine our staff saying, you don't have to submit that now, let's wait. We were probably under the impression that we'd be able to process these by September 7th, and that, until we realize the huge number of applications that we did receive and the backlog that was created and the inability for the county for multiple departments to get, do the inspections and complete all the review, that, we clearly thought at that time that we would be able to process those in the summertime. I can imagine the staff person saying something, in fact, you don't need to submit it right now, wait, but not to the point where you don't have to meet the timeframe. It's unfortunate that maybe the applicant misunderstood what was being said, but we did tell people that you had time to submit these other documents. But again, as I think Supervisor Laddish pointed out, the code is quite clear of the deadline of when it was submitted, when those had to be submitted. And we've been very consistent throughout the process in holding everyone. This is not a change based on change in board direction or board makeup. This is consistent throughout our process of being very strict with the deadlines. If you did not submit, and we have had dozens of applications that we have denied so far because they did not meet the submittal deadline. This is not unique to this individual, and it's unfortunate, but I cannot imagine my staff telling anyone that they didn't need to meet the deadline for that.
Okay, so that would be, just for me, for clarity purposes, you're telling me that because he did this early on, we didn't know the number of applications that were going to come in by that June 30th deadline. The staff member would have said, wait until the September 7th date, or they would have said, don't do it? Because that's a big difference in the comments you're making.
I don't know what staff member actually said. I'm saying I can speculate that we could have told someone, yeah, why don't you wait on this, see what happens, but not at the point you don't have to submit it. Don't wait until after the deadline, but at least wait until they probably did not really think about the fact that the processing would take beyond that September 7th date, given the low numbers we had at that point in time and the expectation that we might have 200 applicants rather than 900 applicants.
Okay. Is there any questions for Peter?
No.
Okay. Is there any rebuttal, Mr. Foley, for...
We'll submit it.
Thank you. Okay, so we're going to close the hearing, bring it back to the commissioners, and have discussion here. Does anybody have any comments?
Yes. It seems to me that whatever was said by the sheriff's department appears to have been a reference to hearing the results of the background check and nothing more than that. That's what I got out of what I heard today. It doesn't make a lot of sense to me that a planning department person would tell somebody you don't have to submit the seller's permitted before September 7th. They may have said, as the planning director has speculated, you have time to deal with this. You don't have to do it right now. But it doesn't make sense that they would say something that could reasonably construed to mean you don't have to do it by September 7th. It's also pretty clear on the record that Mr. Garcia did see the instructions that are very clear on when you have to submit these papers. And if there was a question about it, it seems to me that the applicant had an obligation to check before September 7th. If he had any doubt in his mind, check with the planning department. And it also seems clear to me that just as a legal matter, the staff person just can't waive the requirements of the urgency ordinance. Otherwise, nothing's going to work. So I'm, at this point, in favor of denying the appeal.
Commissioner Sisk?
I kind of agree with Kelly. It's in writing. He admitted he saw it in writing. He had plenty of time. He submitted his application on June 6th. The date is September 7th, so I believe that he either misunderstood him, that he didn't have to have this turned in today. He didn't have to have that, back in June or July. And I believe that I agree. He needs to get it done. I agree with the denial. Yeah, leave it at that.
Basically the same opinion. As I read the declaration just submitted today, it's pretty obvious that Mr. Garcia knew about the September 7th date. He knew about it in June, he knew about it in July, he knew about it in August. All he's really claiming is that the planning staff person told him he didn't have to submit these two items, the seller's permit and the business license, until later. But he's not even claiming, in at least the way I read his statement, that he was told specifically that the September 7th deadline was not going to be enforced. So just based on his own declaration, I think it should be done, the appeal should be denied.
I agree with the other commissioners. I think Commissioner Wooster has stated it very clearly. And I think, especially with the allegation that the Sheriff's Department had something to do with the seller's permit requirement, I think it would indicate that, that Mr. Garcia was probably misunderstanding what he was being told by the department. I mean, it's either that or I just don't believe that the Sheriff's Department would say anything about the building permit. So I fully agree with what the other commissioners have said.
Okay. You know, I have a state license, I have a business, I have a lot of hoops I have to jump through to maintain that, and it's a constantly revolving and changing industry. Every industry is. And to be licensed as a commercial grower is going to require state licensing, it's going to require county licensing. And it is the applicant's responsibility to follow the rules, whether they change or not. Obviously, they haven't changed. Nothing's changed on this ordinance since it was adopted. But I do believe it is the applicant's responsibility to stay on top of their industry, to understand the rules, comply with the rules. I can imagine that somebody at the staff said, hey, you've submitted early. We didn't have any idea the number of applications that were coming in, and we got backlogged. And to wait until he got closer to September, I understand that. But I just have a really hard time someone at our county would say, hey, don't worry about it. You don't have to follow the rules in the ordinance. You can just, skip that process. I don't believe they would have made an affirmative statement to that. So I'm also going to be leaning towards upholding the planning department's denial. So is there a motion to, you want to talk some more?
Well, the draft resolution, I do have some suggestions for it.
We need to read. Yeah, and then he needs to read it as well. So what changes would you like to see before we?
Okay, the last whereas clause has the wrong date. It refers to the public hearing on February 9th.
That's right. That was a good catch.
Page 1, the last whereas clause. Says, whereas during a duly noticed public hearing on February 9th, 2017, et cetera.
And it should be February 8th?
March 9th.
March.
Oh. I was thinking about the
So
earlier.
this was written when they originally were up for an appeal, but then a continuance was
Right.
issued. So the dates just need to be corrected for the hearing
I
date.
was looking at the wrong whereases.
Okay.
Okay. Under the be it therefore resolved, paragraph 1, under evidence, we have a quotation of the urgency ordinance, which really isn't evidence. It seems to me that that quotation ought to go up at the very beginning of the paragraph 1, because that is the finding. And the finding is going to be that there was not compliance with the requirement. And so the requirement ought to be stated first. In other words, Section 17.95.165N 5B states, et cetera, all the way through that quote, ought to be the very first thing under paragraph 1.
So what you're suggesting is to take the evidence, make that the number one finding, and then list the registrant failed to provide the seller's permit, and then number two.
I'm suggesting taking the first sentence of the evidence that ends with the quote, "Receipt of a state seller's permit pursuant to California Revenue and Taxation Code, Section 6001 et sec." That should be the very first thing in the finding.
Got it. I'm good with that.
And then what remains in the first part of paragraph 1 stays the same. Then down below, under the evidence, what would be left is the sentences that begin, "The registrant did not submit this document." I would change that to say, "The registrant did not submit to the planning department by September 7, 2016, any documentation demonstrating that he had received a state seller's permit," because that's the case.
The other commissioners have questions, or are you in agreement?
I'm in agreement.
Okay, then on the last sentence, I would say as follows. "Furthermore, on December 28, 2016, the registrant informed the planning department that he had not yet acquired the state seller's permit," because that is actually the evidence.
Okay. So I have a question. These are some pretty big modifications. Do you want to do it as amended, or do you think we need to make the changes?
I think
The
you're probably
content-
going to be suggesting something for the second one.
Yes.
The content is the same, but we're shifting it around.
I think we can.
I can give Peter a copy of what I read from.
That would be great.
Okay.
I think if you read it into the record and we have a written, I've copied that, we can make sure that the final resolution conforms with what was read into the record.
Okay?
Yeah.
Okay, thank you.
Now we get to paragraph 2, which is going to be even more fun. First thing, I would do the same thing here that I suggested in paragraph 1. In other words, the very first sentence under paragraph 2, which is the finding, should be the quotation from the urgency ordinance. And this one gets a little complicated because of the apparent practice that's been followed, as set forth in the staff report, where the county does not actually issue a business license until the application is complete.
You know, it's getting pretty complicated, and I think in order for us to be able to vote on this, I would like to have you hand that over to them and us take a break here for a few minutes to get it corrected properly so that we can read it before we vote.
I think that's a good idea because
Okay.
it's not going to be
Okay with
that
that?
simple.
Sure.
Okay, so let's take you want a 15-minute break?
Sure.
Okay, we'll come back at 10:05. Is Julie coming back?
Probably not.
Oh, they already got it? Can we go forward?
Yeah.
All right, are we ready to come back to order a few minutes late? So, you want my mic on? Okay, I got in trouble because with the new mics, I'm not used to talking into them. And somebody came up and said I need to control my P's because I'm popping the mic. So I'll try my best. I'm sorry if I'm hurting your ears. All right, so we can go to, has everybody had a chance to read the resolution? And do you have any questions or comments?
Yeah, the date's still not right.
Fix everything else, but forget that one.
I fixed the wrong date.
I'm reading. I'm just going to wait for the commissioners to finish reading the amended resolution before we read it into the record and they vote on that. Commissioner Pacelli, we're watching you in those facial expressions.
I want to look at Kelly. No, don't need to get into it. We're fine.
Is everybody okay with it? Do you need more time? Nope. Okay. Miguel, would you like to read that into the record, please?
Staff recommends that the Planning Commission adopt Resolution 2017-008, thus denying 2016-085 appeal, thereby upholding the Planning Director's determination to deny application 2016-085,
Thank you.
And that would be as amended, a resolution as amended,
as amended.
Thank you.
including the correction of the date to March 9th.
Thank you. Okay. Can I get a motion to,
So moved.
I'll second it.
Pacelli seconding? Okay. All right, thank you. All in favor?
Aye.
Opposed? Motion carries. Okay, so.
So this action is final unless appealed to the Board of Supervisors within 15 calendar days.
Okay, so next item on the agenda is going to be the study session. We actually have one today, which is very exciting. So I'm going to let Peter take over in explaining what we're working on here.
All right, thank you. Since we had a short agenda, I thought we'd take this opportunity while you're here just to sort of update you as to what we're working on in the department, and then some of the things that are on my rather long laundry list of other things to do. Provide some guidance to us. Ultimately, I'll be taking this to the Board of Supervisors because they're the ones that actually provide me the direction, and see what, how best to utilize mine and my staff's time, given what little extra I have between the general plan and cannabis issues. So our two top priorities right now are getting the general plan done and addressing the cannabis issues. We've got still quite a huge backlog, as you heard earlier today, on applications, and we're still trying to get to a permanent ordinance of one sort or another on how to regulate or whether it becomes banned. We're sort of in limbo at this point in time, waiting to see what the outcome of the election will be on May 2nd with the ban initiative. The board has provided us some direction to develop a county ban in the event that there's some potential flaws in the initiative itself. At the same time, to continue working on the EIR so that we can utilize that document for a county permanent ordinance, whichever way it goes. So that's moving forward. I just completed my review of the administrative draft of the EIR. We need to fix some areas to make it a little more accurate and beef up some portions of that, but that should be out in the street within the next couple of weeks.
Now, that's the EIR.
That's the EIR for the cannabis ordinance. And it will look at a range of options, including a ban. The ordinance as proposed by the board a year ago. The original draft is the project description, but also looks at other alternatives as far as reduced impact alternatives. So that's in process. Time frame is 45-day public comment period. Depending on the extent of comments, we'll need to respond to each of those comments in writing, and then we can release the final EIR and start public hearings on an ordinance. That's likely to start at the earliest June, most likely July, just because of the time frames and the amount of work that needed to be done. So it will come to the Planning Commission first as a zoning ordinance, and then ultimate action by the Board of Supervisors. The general plan is sort of along the same time frames, although we're not as far along in the EIR process. I am hopeful to get a admin draft of the EIR in late May or early June. So then we start again that process of review. We'll have, besides myself and our county counsel's office, we have outside counsel assisting us with that. And so we'll be reviewing that very carefully to make sure it's accurately reflects the impacts associated with that and reflects the county's policies. Then again, it will go out for public comment, and I'm hopeful that by the end of summer that we can begin hearings on the general plan.
Wow.
That's very optimistic. The other planning directors, when I mentioned that, they also looked at me like I was crazy. So that's, right now we're sort of in a lull with the general plan process because the consultants are doing the work on that. I'm working with them, questions come up, I'll be reviewing components of it as they complete parts, but it's really in their hands at this point in time for the probably next 2 months or so. As they wrap up their work, then I'll be getting more involved in reviewing the admin drafts of the various elements, various components of the draft EIR.
Okay, just for clarity, you expect the EIR out for cannabis when?
I'm hopeful by the end of the month that we'll have a draft EIR ready for public review.
Okay, and then the
And
one
hopefully earlier than that.
for the
maybe next
general
couple of
plan,
weeks.
we're looking at end of June, possibly?
June or July, probably.
Okay. I just want to, before we move on to all your other topics here that are awesome and important, I just want some clarity because I did receive an email questioning, you speak about the urgency ordinance and the EIR, and then you also talk about receiving direction from the Board of Supervisors to work on either regulation or ban. I believe it was ban is what they had requested.
Right.
They were confused as to why we're working on both, and I know why, but I want to make sure that it is publicly stated why we're working on both.
So we had a workshop on, I think it was January 31st, with the board prior to final action on extending the urgency ordinance last February 14th. At that time, we looked at a range of options of what we could do, and the board's direction at that point in time was to they had placed the initiative measure on the ballot, and so that the voters have the opportunity to weigh in on or to tell us what's wanted as far as banning or not, or regulating. The board majority felt that there was a need to prepare a county drafted ban in the event, I'm sort of speculating a little bit, but should the initiative pass but be challenged in court because of some potential conflicts, either with state law or constitutional issues, that the board wanted to have its own ban ordinance ready to go as soon as possible. Actually, they would have liked to have had it adopted prior to the election as sort of an alternative to the urgency ordinance. They recognized that we needed to have something in place, so I think you might say reluctantly, they extended the urgency ordinance until we could get something in place. But not knowing what the voters are going to say, and the board sort of had a straw poll, and sort of my hearing was that should the voters reject the ban, then we would continue to work on a regulatory program, come up with some stronger regulations to address some of the issues that have been raised under the urgency ordinance, but that the voters would have said that we're not willing to ban it, but we want good, strong regulations. That was my reading of what the board had said in that public hearing, and I hope I'm characterizing the board's action accurately.
Okay. Did the board?
So we're sort of moving on a parallel path, depending on the way the voters decide on this issue, to have a ban ready to go if for some reason the initiative gets bogged up in litigation, but also if the voters reject a ban, then to continue to work on a regulatory program.
Okay.
And we'll be using the EIR that we started last spring, which is about ready to be finished, for either course of action as the most cautious way to approach CEQA on this.
Okay. Just for clarity purposes, because I'm getting a lot of questions, did the Board of Supervisors instruct a ban for commercial cultivation? Did they include dispensaries? What was included in that request?
We didn't get into the details of the ordinance itself,
Okay.
but we've prepared a draft. It would ban all commercial activities associated with cannabis other than dispensaries, which is already regulated by the county code, the zoning ordinance, that's chapter, I think it's 1791. So that was our understanding of the direction, was that commercial cultivation and the other commercial activities such as manufacturing and distribution would not be permitted in the county.
Okay.
Other than what is allowed by right, minimum amount allowed by right under Prop 64.
Thank you.
Any other questions on cannabis at this point? Okay, good. So general plan, we're just sort of in that EIR waiting period at this point in time. We expect to have, we got lots of comments on the notice of preparation. The consultants are looking at that and make sure that we address all the issues that were raised. When the draft EIR is out, we expect to have a huge volume of comments on the EIR itself. One of the things that typically happens is that concerns about the plan itself, policy decisions that were made by the commission and the board, get wrapped up into the environmental review, the analysis of environmental impacts. And the purpose of the EIR is not to necessarily debate the policy decisions of the county, but to analyze the impacts. It ends up with mitigation that the policies could change through the mitigation process. So typically with a program EIR in the general plan or an ordinance, you have what's called self-mitigating environmental review, so that the the mitigation measures are different than, say, a project, where a subdivision, say, to mitigate this impact, you have to, not build houses in this area. Here, the mitigation would be modification of the policies, or some other program that you would do in the future. So that's why the EIR may result in changes to the general plan, but those would be decisions that you and ultimately the board would make by looking at the alternatives, looking at the mitigation, determining whether or not those measures are appropriate, and if you find that no, those really aren't feasible, or yes, they're feasible, but for these other reasons we choose to not accept that mitigation measure, then those would be included in the final findings for the general plan. So there's going to be a lot of work to do in the fall, I hope, because again, my goal is to get this all done before the end of the calendar year. Any further questions on general plan stuff? So then I just sort of did a quick sort of a memory dump of things that we've talked about and things that our department has identified as some needs. And I think I'll just quickly sort of go through that. There's a little over a page of different things. I know that the commission previously has brought up the issue of the plan development ordinance. That's been an issue for some time, particularly in some of the communities where, like in McCollum Hill, where we have adopted design standards that we're using sort of an intent with to use that in lieu of the plan development process. And we just haven't taken that final step yet to amend the code and amend the zoning map to remove that PD overlay. So that's just on the list of things we need to do. And I guess one of my request to you at the end of this is sort of, what's the most important for you as a commission, so that I can include that in a report to the board, and they can then give me my marching orders, as it were. Some of the other things that we've identified is the industrial zone update. For those who are here during the asphalt plant hearings, you probably remember the provision of the code that defers the decision of whether or not a use permit is required or not to the health officer. The environmental health officer really does not want to be responsible for that, and I think it's necessary for us to go back and sort of revisit the uses to try to remove that provision and have it much more clear in the code that these are the kind of uses that, because of their nature, should require a use permit. These other uses, because of the zoning, should be allowed by right, and not have this intermediary step of having it reviewed by another department and almost sort of a unilateral decision by that individual to determine whether or not the hazards associated with the use should be require a use permit or not. So that's sort of high on my list of things that we need to take care of. We have struggled with the short-term vacation rental ordinance for several years. We adopted the ordinance, I can't remember, Annette, when was that adopted?
4 years ago.
4 or 5 years ago. And it's worked to a degree, but I think it needs some refinement. We don't have the ability to really inspect. There's been lots of challenges and issues associated with individual rentals. Not everyone has complied. There's still a number of vacation rentals that haven't even bothered to come in to apply for a permit for that. So that's something I'd just sort of like to revisit and see how we can refine that ordinance, make it a little more functional for both us as well as the community of Lake Tulloch that is affected by those rentals. We're required by law to do an annual housing element review. We adopted the new element back in 2015. I've been unable to complete that review either this year or last year, so we're behind on that. That's very important for us to keep up with that, and I just simply don't have the staff resources to do that at the moment.
Has it been over a year that we did, because we did the housing element?
It's almost 2 years now.
Has it been 2 years?
Yeah.
Oh,
Time flies never.
okay.
So that's very important. That needs to be done. When we forwarded the draft general plan onto the board, we had not finished working on all of the community plans, and your direction to me was, to the degree possible, if we could incorporate a Copperopolis and a Valley Springs component of the community planning element, we should do so. I've worked a little bit with community members in Valley Springs. We had it scheduled a few months ago until I realized that not everyone had been involved in that discussion. We need to take that back and do a little more community outreach on that. Some of the other longer-term items would be oak tree ordinance or guidelines. We're now beginning to see some of the projects that were approved some time ago come back to us for final maps, and some of those requirements to compliance with the oak guidelines. Well, our oak guidelines really don't provide us much guidance. They were adopted in 2007. They are general in nature and not very helpful to the development community as well as us in trying to implement those programs. So it's something we need to work on. That is, I'm saying, notoriously a complex and controversial undertaking. I spent 5 years working on one in another jurisdiction and was still wrapped up in court when I left. So that's a challenge, but it's something that we really need to do to assist the development community so they know they have some clear path on how to comply with these requirements. These requirements are established by state law, but the counties are responsible for implementing those. So it's something that we will need to work on in the near future. It's also something we've identified in the general plan as an implementation program, implementation measure that needs to be done. And then something as simple as the environmental consultant list. There was one that was prepared just before I came on board 3 years ago. It needs to be reviewed and updated so that if an applicant comes in and says, well, I know I need to do a bio study or an archaeological study or a traffic study, who do I go to? We can hand them an updated list to make sure that there's plenty of options for the applicants to do that. So those are just some of the things that I had quick thoughts on, some of the things I need to do. One of my problems right now is I have 2 vacancies on my staff. I have a Planner 3 position, which is really sort of the lead for a lot of this kind of work, the ordinance writing, the more complex tasks. My number 1 Planner 3 left back in November, I think. Recruited to fill that position and was unable to get qualified applicants. So I'm going to sort of regroup and figure out what to do next for that position. I have another staff that just went on leave for a month, so I'm down to 2 bodies right now. And of course, while maintaining our usual workload, we're inundated with all of the cannabis registration applications as well. So we could spend every working hour plus on processing those cannabis applications, but the other components of our department's workload needs to be maintained in a cohesive fashion as well. So we're trying to balance our workload between the cannabis applications. I've got 4 people that I have, 3 people now, extra hire, that have been solely delegated to cannabis registration. They're funded through the registration fees and other staff time. Regular full-time staff is also working part-time on the cannabis stuff, but the other staff, I'm trying to make sure that we keep other development applications in our day-to-day operations of counters and phones and planning commission hearings, going on a regular schedule. So it's been a juggling act for the past, I'll say 9 months at this point in time.
How many applications do you estimate are left?
I think we probably approved or we've taken final action on maybe 250 of the applications, but we are at sort of the tail end of the review. The biggest backlog we have right now on the cannabis registrations is the site inspections. Just getting the code enforcement team out there and inspections. In some cases, okay, there's some shortfalls, but these are fixable things, so they have to go back out 10 days later to say, well, did you fix these things? They made an attempt at, some of the things, like if they just didn't bother putting up a fence at all, we say, you didn't comply. I think we had this discussion previously. It was required when they submitted their application. But if they put up a fence but didn't quite meet the standards that we had expected, we will tell them, here's what you need to do to fix this, and then come back and fix it.
How many are approved at this point?
I don't have the exact number. 2 weeks ago, I looked at the figures, and we had like, I think it was 89 approvals and 95 denials. So I'm, over 2 weeks, we've approved, several more, we've denied several more. So I'm guessing approximately 100 each. We've also had a number of withdrawals. So I think we probably, some action has been taken that closed out that file of about 250 of them. But the rest of them are sort of at the tail end of the review. We've reviewed all of the paperwork as far as their legitimacy of their LLC. Did they have the deeds in place? So we're waiting on pretty much two things: how they pass the background check, that kind of stuff. It's pretty much been all taken care of at this point. So the site inspections and our review of the were they actually cultivating, or had they prepared the site for cultivation as of May 10th, has become quite a challenging exercise. Frankly, we've received a lot of baloney. I'll use a stronger word, but I'll use baloney here in public, of what people submitted to us to try to convince us that they were growing. And it's just so obviously clear when you do the research, you look at the aerial imaging. We've had some of the appeals here, where someone will show us pictures of plants in pots with a date of March, but the grass is brown. This clearly was taken in June or July, or late May or June. And so it's just, trying to weed through all of that. And it's been very frustrating, because I think that had those growers...
They use Roundup,
Yeah.
Well, when you look out over the adjacent hillsides and everything is brown, you go, that's a summertime picture. It definitely was not March, even during the drought time. So that's been very frustrating for me, because if we had not had to deal with bogus applications, we probably could have gotten through the vast majority of them by now and had a much better picture of what was out there. But we're dealing with just a huge number of people that tried to sneak in under the program.
I want to go back to something you said a minute ago. You said you have approximately, no, that's not a definite number, but approximately 100 approved and approximately 100 denied. What's the 100 that's denied? Is that out of the 1,000? You've only got 250 left, so I'm...
No. We've processed about 250. So between 100 plus denials and 100 plus approvals plus withdrawals, we've ended up processing 250. So we have about, 450 to go? No, 550 to go?
But we had 1,000.
We had 900 and some.
Okay, but the numbers aren't working.
Well, whatever the math is.
mental math.
It was, let's say, 950 applications minus 250 equals 700. So we have about 700 to go. Wow. But it's not like 700 from the start.
And
We're
then
probably
you
90% of the way through those 700.
Okay, and then you had a lot withdrawal. for
And then
one
we have a
reason
number
or
of
another.
withdrawals, yeah.
Okay.
How many of the denials have we had to hear from the appeal process?
I think we've probably had, in the range of maybe 60 appeals so far?
Pretty high percentage, isn't it?
Yeah.
Like 2/3.
And I think 2 made it through. Okay. Does anybody else have any questions on those 2 items? Because as he moved down this list, I have questions. Okay. I want to go back to page 1. And you were talking about the general plan. One of the issues, and there were actually 2 issues that were built into that, and one of them was FEMA flood rate map update, which is pretty critical for a lot of people in this county. That process is where? Expected to be completed in May?
Yes. So we've been working with FEMA for the past 2.5 years. We finally convinced them that the maps that they were using that were adopted in 2010 were inaccurate. And it took quite an effort to convince them that we really need to go back and revisit those maps. We had previously approximately 2,000 lots that were in the floodplain prior to 2010. when they adopted the new maps that were based on some State Department of Water Resources floodplain awareness mapping, which was intended to be used for planning purposes, but ended up being adopted by FEMA as the maps.
Right.
We just found, it added another 5,000 lots to the floodplain, and that created a huge mess, because people were being charged for flood insurance when they didn't need it. In some cases, you'd have a stream valley, and the floodplain was on the hillside rather than, at the bottom of the canyon. So clearly they were inaccurate. They finally recognized that fact. They had done 2 separate studies. One was upper level, the upper reaches of some of the streams. And when there was less than a foot of flooding, and it was, I don't remember the exact details of, they said, the risk of flood here is so low, we don't need to include those. So those were dropped out. And then they looked at some LiDAR mapping that was done and some other studies. When we get to the point of the adoption hearings, Deborah Lewis and my staff, who's been doing a tremendous job on this, knows the details down pat. I rely on her to take care of that. So these 2 different studies clearly showed much more accuracy of where the floodplains were. Now, in some cases, they actually expanded, where the awareness floodings were just sort of a general line through the stream based on the LiDAR that looked at actually the topography. You said, oh, well, in this area, it actually expanded because we got this low area, but other parts are constricted. So I think that, I don't remember the exact numbers, but several thousand lots have dropped out for that. And these now, we feel comfortable that they're accurate, and that we can rely on those for accurate assessment of the flood hazard. So we're in the final process now of, it's been out for public review. We got the drafts late last summer, early fall. We viewed those, sent our corrections back to FEMA. They agreed with all those changes, and now they're out for public comment. We're probably getting 3 or 4 calls a day from the public about, well, how's this affect me? And Deborah's handling all those. For the most part, I think we're pretty satisfied. Excuse me.
And this is separate from the general plan.
This is a separate action from the general
yeah,
plan.
this
This
is
was
FEMA.
just something that was a big issue when I first started here. I'm sorry. And we've finally been able to resolve it. So those maps, the public comment period, the public review period of that will end in early May. So then we'll be bringing that to the board for adoption of those. And I can give you a more detailed report on that at that time.
And then you talk about the San Andreas circulation plan that COG is the lead agency on. That's just a grant to do the study of the issues in San Andreas, because obviously we all know there is serious issues in San Andreas with crossing the streets and those issues. That would be in here because how would that be moved forward?
Well, that is moving forward, and it's sort of on its own track. That started off when we had proposals for development on the south side of town, and specifically off of Airport Road. And there was a proposal to put in a store and subdivide a larger piece of property. And we started working with the applicant and Caltrans as far as how to get access. And immediately it was, we need to put a turn lane in. Well, a turn lane on the state highway where a passing zone is just a project killer. And those improvements are something that serves a much larger area. So we started off looking at just sort of what we call the South Gateway, that area up on the flat by the old airport. We've had for many, many years, that's an area that's been designated for future commercial and higher density residential development. And we want to accommodate that, come up with a program that enables individual development to move forward with sort of incremental improvements to the circulation system. So we've talked about that internally with Public Works staff, and then COG routinely applies for different kinds of grants from Caltrans for different highway improvements and often some studies. And so we talked to them about that and said, oh, I think this actually might fit one of the grant programs. that sort of expanded because of the parameters of the grant to look at much more of the corridor through town. And it really is connected. The intersection out here at Mountain Ranch is intricately tied with what happens up above because of the speed of traffic and the downhill curve and not being able to see. Putting a stoplight there without any other improvements would never work. There was a mobility study that was done some years ago that had, I think, 9 roundabouts or something, and that was sort of a pie-in-the-sky ideal kind of program. So we sort of revisited some of these older studies, and now we're in the process. I have an admin draft of that plan in front of me. I'm going to be meeting with the fire chief, where we've got a public meeting scheduled coming up in the next couple of months on that. So that project's wrapping up. Again, COG is the lead on that, but working very closely with me and public works staff to see what happens. So we're looking at ways that we can improve pedestrian access crossing the highway while at the same time maintaining through flow through traffic. So it's a balancing act of sort of slowing traffic down but not bringing it to a stop to accommodate alternative means of transportation, and particularly pedestrian safety, getting to the school. I think it's been a very successful program. Ultimately, what we want to do is bring that to the board for adoption. This has been sort of a problem we've had in the past of a lot of projects that studies have been done, but they've never gone the final step of being adopted. Once we have an adopted plan, we can use that as a basis for grant money from Caltrans to actually make some of those improvements, which has been the biggest problem. They're great, but where's the money coming from? We could sort of incrementally make some of these things. And then particularly on the south side, as development comes in, they'll know what they need to do to make their project work, where connections need to be made, where there be major intersections on the highway that will allow for the free flow of traffic, but also allow for circulation within the development. So that one should be almost along the same time frame as the cannabis EIR, as far as being ready. I've got an admin draft that I'm reviewing right now on that, and then we have a series, we'll be scheduling a series of public workshops on the draft proposal later this spring, and then hopefully the COG board and our county board will be adopting that plan, or a version of that plan, in the summertime sometime.
Okay. On the other items on this list, because I look at this list and I think, wow, I see all of them as being each having their own importance. Mm-hmm. I'm selfish, I have my own issue, which is the PD. But these are all equally as important, no matter what district they're in, what area they're in. I see all of them having big issues. So looking at it from that respect, what is it that you want from us today for guidance, or is this just that you are reviewing this with us and then you're going to take it to the supervisors for categorizing? What is it that you're looking for?
Part of it was just information, so you had an idea of what's happening in our department. But if there's something here or something else, or maybe something that comes in from the public that says, well, this is really important, that if you feel strongly about something, let me know. If I have to choose, I'm going to have to choose, of these, what I can do. What's the most important? What's important to you as a commission for me to focus my efforts on? And then I can help build my team and my budget around that.
I think, too, that you can balance the importance and how much actual time is going to take of the planning department to accomplish something. Like the Valley Springs community plans, I understand that it was pulled because not everybody had been heard from. I wonder if that's something that I know there are a lot of people very interested in getting the Valley Springs community plan in, and it sounded as if it was getting very close. Is this something that the planning department can just have somebody keeping an eye on it and pinging on people every week or something without spending a whole lot of time on it, so that can get back to us?
Potentially, yes. It also could just totally blow up in my face, too.
Yes, no, I know, and then,
I mean, in an ideal world, yes, we sit down, we make some minor changes to it, and then we move it on to the commission and the board. But in the worst-case scenario, there's no agreement, and it's sort of back to the drawing boards. So, but I think that right now, I'm the eternal optimist. I think we can get it done fairly quickly.
I guess what I'm saying is that until everything falls apart, I mean, if these people are very interested in getting a community plan, they should realize that they need to get together and not cause your department a whole lot of time and effort, because it will drop in its priority. But in the meantime, I'm hoping that you can apply whatever facilitating effort is needed without spending a whole lot of time on it. Without your spending a whole lot of time on it.
So to answer your question, Lisa, if you would like to weigh in on what you think are important items, that sort of helps me then, and I can relay that on to the board as well.
Well, number one is going to be the annual housing element reporting. That we have to do. For me. I
And
mean,
we're already late.
Pardon me?
And we're already late.
Well, here's the thing, that plays a huge role in us maintaining, we're trying to get the general plan current and keeping that housing element current as we proceed through processing the general plan, obviously is priority. These other items, to me, are personal to district areas. Industrial zone update, obviously we went through a large issue on that through asphalt. That, the biggest complaint is how do we bring industry in? How do we streamline the process? And I would hate to miss an opportunity to see an industry want to come in, but yet we don't have clarity and we end up in a fight again. I would really like to see some clarity on that. For me, personally, I understand the Valley Springs community plan's a big deal to them, and that's a big community effort that needs to be done. That's where I'm saying it breaks down into separate guidelines. The oak tree ordinance guidelines don't scare me as much because we addressed that in the new general plan. So in my thought process, that's moving along with the general plan as we speak. So I understand you probably need to have something now to work with that you don't. But if that one wasn't first on the list, I'm not afraid of it because it's been worked on. Obviously, I want PD. I want to discuss PD. I want it's stagnating my area. It is. I talked to the people that worked on the plan, and they told us why the committee that worked on it put it in there, and that it took on a life of its own. It's no longer the original intent, and it hurt our community. That is the biggest issue for me, is moving the PD forward. Obviously, I'm going to have to back up. I have to say this, the housing element number one, period. That has got to be done because that's going to move through with our general plan. That general plan is number one, period. I don't have another issue bigger than that. So keeping the housing element up to date would be number one. When I look at this list, I want to go to PD, and then I think everything, they all have priorities, but I'm being selfish in saying that PD is stagnating our county. And everyone talks about we have no industry, we can't open businesses, the cost to open a business. We need development, we need mom and pop to be able to open a door without having to pop $10,000 before they can ever think about opening a door. It's huge. That's tax revenue to our county, that's economic value to our county, and that is stagnating us really bad. So that, for me, is my number one issue, and I know that each district is going to have a number one. So I would like to give the other commissioners time to talk, since I feel like that's all I've done.
Well, I think plan development ordinance is very important, and again, I'm not sure, I guess there isn't a cookie cutter plan development ordinance, I mean, an alternative to what we have. There isn't a cookie cutter thing that you can just pull from Siskiyou County or something that's going to work. I mean, how much of a project is there for the planning department in doing this?
There are multiple examples of successful ordinances out there that we could use as a guide to help us create something that works for us. The biggest issue, I think, is looking at where we've had in various communities a review process in place. Now we're going to propose to remove that in many cases. Do we need to put in something to replace it, as we have in McCollum Hill? Creating design standards is a large process. It involves, community involvement. To be successful, to be effective, you need to get community involvement. You need to say, okay, what does the community want here? To me, that's the most exciting part of planning, is working with the community, figuring out what they want, and then crafting rules and standards and procedures to make that work for them.
I think that's already done in my area. If you look at the community plans that are being pulled back because there's so much stale dated stuff in it, the one thing that is consistent from
And
past...
so maybe there's some of that already in
It's
there.
already
So it's
there.
a matter of getting that, updating it. It can be a huge task. It could be fairly simple.
And can a lot of community, realtors associations or whatever, can't they be working on this to come up and make proposals?
Well, essentially what happened in McCollum Hill was the community got together, activists in the community said, well, we want our own standards. So the board sort of granted them the ability to create those standards, working with staff, and they did so, and it was adopted by the board. We could sort of take this in pieces. We could, for example, remove the PD zone in McCollum Hill. Just look at McCollum Hill first,
Right.
and get that done.
Yeah.
And that would be a fairly simple process. We could then look at what do we have in place for other communities, and as we develop standards in those other communities, where the PD is sort of the inherent process that we have now for anything to be developed. Once we have something in place to sort of substitute for that, or maybe the decision, we don't need to have anything. We're willing to just let the property owners decide what they want for their property, as long as it's consistent with zoning, and not have a design criteria that we have to go through.
We addressed that in the new future general plan as well, where we talked about each area having, each area is so diverse. So what would work in Dorrington doesn't work in Murphy's. Now, Murphy's does not have PD at all. That is not an overlay down in Murphy's. It starts at Forest Meadows up to Tamarack.
Okay.
So when I talk about how PD has stagnated that area, look at the growth in Murphy's with no PD. It is explosive. And then you come up the hill and it rails. It's terrible. They did have a community plan. It's also dated, but their plan addressed what they want their town to look like. It's a historical town. It's got those design standards that were addressed there. It would be simple to say we're going to be consistent with what we've used. In a town like McCollum Hill, historical once again, they came up with what they want that to look like. We continue to move projects forward in areas that don't have PD, and we stagnate whenever they have PD. So I would like to see mom and pop be able to get moving. We have had so many people talk to us about opening a business, and then they go, oh my gosh, I can't afford this, and they walk away. We shouldn't have that. We should have an open door and be able to help people get going. I think that through the new general plan, we worked on diversity. We talked about how different areas have different needs. Valley Springs is a perfect example of an entirely different situation. I think PD works in more urban areas, but when we get into real rural areas, it hurts, is what I feel. I think as each area wants to weigh in, hopefully people are reaching out to their commissioners and saying, we have PD, we don't have PD, we want to keep it, we want to get rid of it. I can tell you just from sitting here for a couple of years, I know McCollum Hill, they're ready to roll. Theirs would be the simplest to deal with right now. They have got it in order. They had community meetings. It's a beautiful program you guys have set up. Compliment you.
I won't take credit for it.
Well, Fawn can, because she worked on that tremendously, and I give them credit for the way they handled it. I want to see those opportunities come forward for communities. I want to get the community's input. I've been since I started here a couple years ago, that is the one and only thing that my district is lit up over, is get rid of it. Get us back on the road to recovery. So that's a big deal in my district. I don't know about the other areas. They may want to keep it. Valley Springs may love PD and say, hey, that's what we want. I don't know what Copper has, if they have PD or not.
There are a few individual parcels that have a plan development overlay on them,
And you've
but
seen-
not generally applied to the whole community.
Okay, so, that's gonna be, that would be my number one item for me. I think for you, PD is a number one issue. Commissioner Bocelli, I don't know what your district area is looking at, is,
As of this morning,
as of this list,
Or
this
anything
morning.
else that's important to the commission and the community.
I believe the industrial zone
Yeah.
aspect may be about to hit the streets.
Okay. And that's something that needs addressed, I totally agree on that.
Yeah, it's in industrial zoning right now.
Okay,
I believe it's number one.
you guys want more cows, huh?
Can't have too many cows.
I have nine.
Looks to me like the priorities ought to be fixing what's causing problems with the public and the business owners, and what's causing problems for their department, in ways that can be fixed with the resources that we have. And just listening here, seems to me the housing element thing is number one, because it is a state law requirement. I would put the planned development project second, because it seems to be eminently doable, particularly in steps, as has been discussed. Having gone through asphalt, I think the industrial zones update would be, I think, the next in my list. And after that, they sort of fall into a lower level to me. The Valley Springs Community Plan, I think, resides more with them than it does with the planning department or this commission in getting that done. The updating the environmental consultant list, if that can be done easily
Get it done.
and be helpful, I think I would look at that next. That pretty much covers my comments. The short-term vacation rental ordinance at Tulloch, I don't know how problematic that's been for the department. And so I sort of leave the judgment on that to the department, because you're the ones that have to deal with that.
Yeah.
And we haven't had a lot come before us here on that. What we did have, we were able to handle under the existing ordinance. So I don't know where to rank that.
Do you want to open up the public?
I would like to hear from the public. Does anybody have any public comments they would like to make?
Marty Crane, I really appreciate this conversation. I just have I don't know if any of you were like...
I'm sorry.
I don't know if anyone was really, I'm sorry. I don't know if anyone remembers this or not, but when I first came here about 25 years ago or so, I wondered why all of a sudden the shopping center in Valley Springs didn't look like it belonged there. It was like pulled out of a, I don't know, Stockton and stuck there, you know? And of course they've changed the colors since then, but still it's stucco. But I wondered about that and I asked, and I seem to recall someone telling me that there used to be a design standard in Valley Springs. And then when those people in that group kind of took a break or whatever, nobody paid attention, and in Valley Springs it was, hey, anything goes. And so I'm a little offended by that, and I would like everybody in the county to pay as much attention to what it looks like and feels like for the people that live in Valley Springs as they do for the people that live in all of your other districts. We love visiting all the districts. It's sad to drive through Valley Springs sometimes and go, you know what? I wish it was more than us that just paid attention to this. So thank you for your future consideration.
Thank you.
Good morning. Colleen Platt with My Valley Springs and the Calaveras Planning Coalition. Some of us discussed these, the priority list Monday, so I just have some feedback on the priority list from the group. The plan development ordinance, I like the idea of what I just heard of doing it in pieces in different areas of the county that would be the easiest ones first, and then, getting to the other areas. And I also like what Peter had to say in the staff report about not removing it without having something in its place. As we just personally, we look around us where we live in Valley Springs, and I looked at the zoning map. We have approximately, I'd say, a dozen parcels that have the PD designation on them. Most of them are commercial parcels along Highway 26, the heavy view corridor as you're driving into town. 2 of those parcels have been through the plan development permit review for a project already, and they've gone through that process and they've been approved. They haven't been built yet, but they've been approved. So that's just our experience of the PD in our area. One was a shopping center, and one is the Mark Twain Hospital Center that's to be built there.
Okay.
Yeah, that was a PD also. So I don't personally know the cost to the developer of that going through the PD process. Evidently, somebody said $10,000. I'm not sure.
I was just throwing a simple number. That
Okay,
was not an
yeah.
accurate number.
Okay, I don't know the cost. To the community, we appreciated the process because it brought the project forward, and we were able to see the proposal and the design and what the buildings would look like and the landscaping, and that we could see that this would be a betterment to our community. And so we appreciate that process. Some other parcels in the area that did not have the PD on them went in without any community input at all, and some of those buildings are not the most attractive in the area, and I won't name names, but they're not something that we would be necessarily proud of the look. So that's something to consider when we look at that for our area. So to move on to the list, we also support the industrial zones update. We support the looking at what uses would require a conditional use permit, because we believe that if that had been clear in our code, it could have saved over a year's worth of public appeal hearings in front of the Planning Commission and the board. And you saw the public, how excited they got about that. So that would be something we would definitely support making clearer in the code.
Which way would you?
Pardon me?
Which way would you have it?
We would, the community has always supported a conditional use permit for a use like that would affect a residential neighborhood. Is that particular location of the asphalt plant was going through a residential neighborhood, and the community wanted to be able to give input and have some conditions on the use and when, the hours and the number of trucks and everything. So
Do you have a position on things other than the asphalt plant?
do we have
What other types of industrial uses would you?
I don't know that we've ever even discussed that. That's just the one that pops into mind that divided the community for a year and a half. So we would like some further clarity in that code. And so I don't know. Your guess is as good as mine as what other industrial uses might come up. Well, that's what the purpose of that discussion would be. What other industrial uses would be considered in that code, and that would be the purpose of the discussion. So that would be a good discussion to have, because we do have other M2 zones in Valley Springs. So that would be good to list. And then just to, reiterate, we are, of course, interested in the Valley Springs Community Plan moving forward. We've done everything that we can on our end of it. We've talked to the planning department about combining the plans a couple years ago. We talked to the Planning Commission last summer about combining the plans, got direction to do that. We did our best to combine the plans, and we handed that to the planning department, and they were very busy last fall. So they didn't get to that right away, but after the election there was some time, and they've edited what we gave them, and now it's waiting for, I guess, public input and for it to go in front of the community. We're not the ones to do that. We can't do that. So it's on hold right now, but we would like that to move forward if possible. We're just hoping that will be possible. And the very last thing is the oak tree ordinance. That might be a difficult, as you say, complicated thing, but if you let it, I understand it's part of the general plan, so it will happen eventually. But if there's a chance to address it sooner, rather than each project coming forward and then people getting exercised and excited about oak trees getting cut down, it would be nice to have a program in place, or, you know, something in place that the developers could go, okay, this is what is expected of us and we know what to do, rather than having to be a project by project fight, which it has been in the past. So if there's time to do that, that would be a really helpful thing to do also.
It would be interesting to see the EIR report on that versus the new general plan coming up and being able to take snippets of that.
Sure. Oh, and one other plug. You said we could also bring up other ideas. So something that's been in front of the Planning Commission on and off for years and years, since even before Peter's been here. And I think been on the, I don't think any of you have been on long enough. Fawn was. The dark skies and lighting ordinance. That's been also a project by project discussion. We have a commercial, in our zoning code, commercial is supposed to downlight their lighting on their project, but residential, there's nothing in our zoning code. So this has also been a project by project discussion every time we have a new project going up, that we have to say, could you please downshield your lighting on this new residential project? And there's no requirement to do that, so it's a project by project thing.
There will be in the new general plan.
Yes.
We just got to keep moving
I know,
forward.
I know. But if there's extra time, you know, there's been draft ordinances written. There's been a draft oak ordinance written over the years. Many of them, they're ready to go, at least to look at. There's been a draft lighting ordinance written. So if there is a time sometime, that would be nice to look at also. Thank you.
Thanks, Colleen. Anybody else have any public comment?
Hi,
Hi.
Cliff Edson from San Andreas. First of all, the ordinance application process, in my opinion, that should have been separate from the planning department. Just get it out of the planning department, because there is confusion there, I know there is, and combining jobs and things like that. It's hard on people. So it'd be really easy just to get a project manager, and I'm assuming that you have some folks have been there for quite a while already, put them in a different area and let planning be planning. So that's just my opinion on that.
Just, are you referring to the cannabis ordinance?
Yeah.
Okay.
Yeah. Because if it moves forward in any regulation way, it's not going to stop being smaller. You know, the difference is the sheriff's office is going to have it all, or it's all going to be, you know, spread around. So, and once the processes get down and you know, things start moving forward, then you'll probably be able to manage it out, you know, any way you choose at that point. But it would just seem to be, when it was over here next door, it seemed to be a little bit more easier on planning, even though it was nuts. I know it was nuts. Yeah, you know, most of those applications came in the last 2 weeks. I don't know if people realize that. I mean, there was nothing practically until the last 2 weeks, and that was really hard on staff. Housing element, I agree, is a priority. So, you know, the law is what the law is. PD, I don't like PD. PD puts restrictions on property owners. I believe that a business will, if the business knows that the community is interested in a certain style, per se, then a business will move in and they will adapt to that, because that's when they're going to do business in that area. That's what's attractive. That's what they'll do. Murphy's is a good example of that. Otherwise, you know, it was talked about the Mark Twain Hospital moving into Valley Springs. Well, PD is one of the things that held it up. So, and cost them a lot more money. Because then the Army Corps of Engineers had to get involved and on and on and on. They should have been up and built by now, actually. But this is a good example of how it costs extra money for any business or an organization like that when they have all of these extra regulations that are just overlays on something else.
Cliff, can you know any of the details on that? I've heard that story also, but
Yeah.
I've never heard any specifics.
Well, I know that when I was involved in it, that the shovel-ready date was going to be September of 2016. All right. Then more and more came onto them, more and more details, restrictions, that sort of thing. As a matter of fact, I believe planning had their documentation from them and in place March of 2016. I believe their requirements were there. And so there were things holding them up. PD was one of them. They had to redo the lot, re-engineer the lot, I believe, get new plans on it because you know, when it rains here, there's puddles in places. Well, that place had been graded many times because of a previous project. Well, since the previous project changed, it became a different project. They pretty much had to do everything all over again. It's ridiculous.
How did the Corps of Engineers get involved?
Well, because there was a mud puddle out there somewhere, and it was identified as a wetlands. And so they had to build a sidewalk to nowhere around it. So.
It's the second sidewalk to nowhere in Valley Springs.
Could be. You know, I don't mind things being done right, but I also have an issue with unnecessary expenditures for a business. It chases them away, and it makes them not want to come here, number one. And number two, it costs them sometimes more than they can actually afford. And then you want to talk about why your mom and pops can't open up stores? And you know, that's it. So what are we stuck with? We're stuck with mid-corporate entities that will come in and they will do it. They got the deep pockets. Okay. Next, industrial zones. I think that's a great idea. If we didn't have to deal with that, we wouldn't have had a division of the county. Number one, you know, it was explained earlier that the public got excited about it. Well, the public got excited about it because of the poison pills that were thrown out there and all the misinformation. And so it'd be really great to be able to bypass all of that politics and have something in place that is just that people are assured of what can happen, what their requirements are. As it turns out, they left somewhere else. But, you know, even a golf course left somewhere else, or left. So, you know, you want to talk about chasing out industries of all kinds? What else? What else comes in? So, you know, we should be able to work with groups or industries or businesses to be able to help them be compliant, not chop their neck off before they get started. And if they don't want to work with you, then that's when you can go after them, but not, you know, not start off that way. Valley Springs Community Plan, I think that's really important. It's a monkey on the back. It's been here for a long time. I think we need to get past it. I believe that for the general plan as well, because that is going to be involved in the general plan. The biggest issues around that were there's so much division in Valley Springs area, which is not uncommon. that maybe it's a good way to have less division there by finally getting a community plan in place. And that would help the whole county, actually, because it would probably save a whole bunch of money from all of these appeals and everything else that goes on every time somebody wants to do something. But I like the idea of the way you did the other community plans. You brought them to the Planning Commission. You went through them line by line. Perfect. As long that's an open and public process, I'm very agreeable to that. I think it's a very good process, and that allows everybody to come in and have a say in the matter. So.
Can I interrupt you and ask a question on that?
Yeah.
Actually, I want to ask Peter.
Yeah.
This draft general plan we have, September 22nd, is that the latest one? I don't see the Valley Springs plan in here.
It's not in
Not
there.
in there.
But you said that you combined them.
No. I think what Colleen Platt was referring to was some years ago there was a
All right. Well, I
grant-funded
just
plan.
misunderstood that.
Yeah,
Okay.
and then there was the
That's all right.
alternative plan, and those two were trying to be merged together, and then we end up incorporating that into the general plan.
Yeah, so we tried to get the general plan moving, right? We did that. The community plan, Valley Springs community plan wasn't input into it. There was great division. The goal was as soon as possible, and Peter has been doing this, is to try to get the Valley Springs community plan in as and either as the general plan is moving along or as a general plan update. And I mean, he's doing exactly what he said he was going to do, and I certainly appreciate that. So I'm just saying that it's important for that community down there. I think there's a lot of folks that would probably come to that meeting and have input, and that kind of, I don't know if that puts a bigger burden on your crew or not, but it becomes a part of the planning commission process as well. It's there. I believe these guys said that they submitted something. It's there, and you've had some improvements or changes on it to be able to bring it forward. It's just a process, in my opinion, through the planning commission. Good open public process. When it's done, it'll be done. And so that could be, I think, done fairly easily and quickly. Dark lighting. So dark lighting, I think is probably pretty good for those big industrial areas or commercial areas because they do light up the sky. I mean, I've been up here for quite a few years too. I kind of like looking at the stars. But on my property, I don't want anybody telling me what I can do and what I can't do with it. So, there's a lot of reasons why I may have a light outside. Maybe I'm scared of the dark. Maybe there's been mountain lions out there, which I've seen plenty lately. Maybe there's a lot of different reasons. And so the more we start getting into personal property rights, the more I'm going to be against that. So I'm really not for that part of it. But I am definitely agreeable to large projects like these commercial areas and any industrial area that may come in that has that could have a really impact on the dark skies beauty part of our county. So, and that's all I have. Thank you for the time.
Thank you. Any further public comment? Okay.
So I have a question.
Sure.
On the oak tree ordinance, are we compliant with state law now?
We are complying with state law.
But it just is a case-by-case basis?
It's a case-by-case basis.
And all we have in place now is the voluntary oak management plan from 2007?
Yes.
Okay. And that's purely voluntary? It's a guideline?
It's a guidelines, yes.
Well, I think you're absolutely right that it would be good to have something in place so that we know what's going on.
Well, there is a statute.
Meetings that fell over the last few weeks, big ones. You want to put a manzanita plant out there?
No thanks.
Tell me how to save them.
There is a statute that does have a list of mitigation measures when a project involves a significant impact to Oak Woodlands. So there is something out there. And we are in compliance with the state law. I do agree that that's going to be controversial and lengthy because there's oak trees and then there's oak trees.
All right, any other comments?
Thank you. This has been a helpful discussion.
Well,
The public
I think that was really interesting about if we're looking at these community plans, because many of them are written, many of them were rewritten through when we worked through the general plan process. And if we could expedite that process by bringing in what has been submitted and hold a hearing and move it forward, that would be simple. That was a pretty good idea, instead of having to try and rent halls and move staff out at night and do these big, I mean, the bulk of that work is done on those plans, and you could just put it on an item and bring everybody
Well,
here.
and that's why it was, when I suggested to the board a year and a half ago now that we could incorporate some of the community plans in, because particularly in District 2, the work was primarily done. It needed to be, sort of refined a little bit to fit in with the format of the general plan, but the work had been done because of the years of
Right.
work done in all the communities. Tim, you were involved in a lot of that in the Sheep Ranch, McCallum Hill. There was a lot of work that was done. The problem with, as I saw it, with both Valley Spring and Copperopolis was that there wasn't necessarily a community resolution that, particularly what I experienced at the public workshop we held on the general plan in Copperopolis is community was split down the middle. And to try to come up quickly with a vision for the community that the majority of people agreed with was going to take some time and was going to take workshops and working with them and trying to figure it out. And it may have been that, and sometimes community is just polarized. It's just, they have two different visions of what it should be, and you can't convince the other one that the other vision's right, or you can't come up with a combined vision that sort of works. I would like to do that. I would love to spend the time doing that, but to move the plan forward, to get a general plan adopted, we can do that later. As much as I would not like to do it later, I think we just have to say, okay, we can incorporate these because the work was all but done. The other ones, there's still a lot of work to do. And then we haven't really started with updating plans on the Highway 4 corridor, Murphy's, Arnold, those communities. And so, yes, there is a lot of existing stuff, but it's going to take some time and effort to bring that to a point where it could be incorporated into the general plan.
I wouldn't, the Highway 4 corridor, I agree with you. We're kind of in the upper corridor, not ready for that. But if Copper and Valley Springs have reached a stalemate as far as 50% want this and 50% want that, that means it sits there and it doesn't ever get done. But by doing what Cliff had suggested, bring it here. Let the parties know we're going to do it here. Take it line by line like we did the general plan. Get public input on every line and help them get over the hump and get it implemented. It seems like it's very important to both sides to get it implemented, not one side or the other. Everybody wants it, from what I've heard through public comments. And if we were able to help them break it down in a line-by-line process, getting feedback from those that are very, very interested in this and move it forward, I think that would be progress for their communities.
From the little I know of the two situations, I would say if we were going to try that process, we'd try it with Valley Springs first.
Well, we're further ahead with Valley Springs.
Yeah.
Definitely.
You thought you had consensus.
Yeah.
They have something for us to go line by line with.
If you thought they had consensus, well, there must be a lot of people who could agree with what was proposed. So that might be worth a try. I think, from what I've heard about Copper, I think that would just be a melee. And
It did.
for us to determine we would be determining what the community should want.
Well, it would just, take me or staff or a consultant some time just to go back through the long history of the planning efforts in Copperopolis, just to get to that point where we had something we could bring forward.
Which gets
But-
us back to the question of,
What are the
from the
priorities?
time you have
Yeah.
available, what can we get done?
Yeah.
State element, the housing element, we got to get that done.
Yeah.
But I think that if we have a short planning day and we could bring the actual document forward from Valley Springs, publicize it really well, make sure everyone knows, I think we could crunch through that with public comment and move it forward, and that's progress. I like it. 2 or 3 meetings? No, we do things in one.
These guys are
Valley
effective,
Springs is
efficient.
not going to happen in one.
That plan is pretty well drawn up. We might be able to line item it
Well,
like we did
I
the
will, I will
others.
see what I can do, and if I can maybe reach out to some of the community members to get some additional feedback before we do that, then. So what I hear then is that of the things on the list, the housing review is number one. Both the industrial zone and the PD ordinance are important, something we need to be working on, and to the degree that we can bring the Valley Springs back as quickly as we can try to do that. And the rest we'll just have to sort of see how we can fit it in with everything else. So thank you for your input. I'm going to be packaging something up for the board for, just so they know what I'm doing and they have a better idea of my task, and I can get direction, because ultimately they are the decision makers, the policy makers, and they provide me the direction of what they want me to do for the.
I think that short-term vacational ordinance has some pretty big priorities too, because of all the items on here, that is one that we've seen come back. That's one we've gotten a lot of input on. If that could help the planning department moving projects.
It's probably not as critical in the
Okay.
big picture, the larger scheme of things, but there have been problems associated with implementing that ordinance at the staff level. You don't see it necessarily as much as we do at the staff level.
We hear it about at the realtor
Yeah.
level. Okay, awesome. So that is going to end our study session, and we will go to public comment on anything not on the agenda that we spoke about here today. See several people just sitting and watching and listening and not speaking. We welcome you to the mic.
We've spoken on everything.
The public always has something to say. Okay, well then we're going to wrap it up, and we'll...
There's one last thing, and what I'd like to do starting the next meeting is add an item to the regular agenda, and that's going to be planning commissioners' reports. Doesn't mean you have to report anything, but if there is an issue that comes from your agenda, or some concern, or maybe you have attended some meeting and you want to bring that information back to the rest of the commissioners to share that information, that would be an opportunity for you to do that. So starting next meeting, I want to have just a standing item of commissioners' reports, and it's just an opportunity for you to bring information to me or to share with your fellow commissioners. It may be that there's nothing to share, but just have that opportunity.
Thank you.
So keep that in mind for future. I have nothing else under department report. We've covered everything we need to cover.
Everybody good? Okay, meeting adjourned. Thank you all very much.